First of all, as one of the co-chairs of the symposium, together with Dr. McNeil and others, I would like to welcome everybody to the Legal Symposium. I'm sorry I couldn't be there in person, but I don't travel without my son. He has way too many exams right now, so I had to stay in Montreal. Here it's past midnight, and I'm not a night person, but I'll try to do my best and stay awake and do my presentation. I'd like to congratulate the great attorney Matthew Nolan for his lifetime achievements and for deserving a symposium in his name. So he's an example for many lawyers, including myself. And I would also like to greet and welcome my great friend, Dr. Pana. She'll have a presentation later on. We met together 13 years ago at New York University School of Law while we're doing our doctorate courses. And I invited Edna to this conference to do a presentation, but I couldn't come myself, and I feel sorry about that. It's like inviting people over and not showing up, but she's in good hands. And I've been seeing her pictures posted on Facebook. She's doing really well there. So my field of research lately has been restructuring, company restructuring, and worker participation rights during company restructuring. This is an interesting subject, especially now during the times of COVID, where the company restructuring numbers are really growing, and there is a high unemployment resulting from these company restructurings. If we see at some numbers, there are 100,000 jobs were lost in Quebec manufacturing sector only between 2004 and 2010. These jobs were lost as a direct consequence of restructuring. Between 2003 and 2010, approximately 3,388 restructuring events were recorded in Quebec in all sectors. Between 1988 and 2002, approximately 11,000 Canadian workers aged 24 to 64 lost their jobs due to company closures and mass layoffs. And lately, with the COVID, during the COVID era, we don't really have a number of restructuring recorded yet, but we have special examples. Why we don't have a number yet? Because it's still going on. Companies are still closing and restructuring. So we can't really have a specific number on that, neither in Canada, Quebec, or worldwide, I would say. But we have specific examples, like, for example, Airbus is one of the companies which proceeded with the historical restructuring involving thousands of job cuts, as its production is reduced and its output will be held down by 40% in the next 2 years due to COVID-19 impacts. We also have an example in Canada. The Dominion company is the largest independent producer of diamonds. It employed approximately 1,000 people, including Indigenous employees. And this is very important because there is a high unemployment among Indigenous employees in Canada and the United States as well. And this company during COVID filed for creditor protection due to COVID negative impacts. And this company was the largest non-governmental employer in the Northwest Territory, and it obtained the protection, creditor protection, allowing this company time to find solutions through restructuring in order to stay in business. Why this is important, just in the case of Dominion, and then you can imagine for other cases, it's important for Dominion to stay in business because a variety of stakeholders will be impacted by bankruptcy of Dominion. These stakeholders are employers and shareholders, employees, past and present, because the past employees are affected for their pensions and the present lose their jobs, Indigenous community as well, contractors, other businesses that work with Dominion, the government that has to provide benefits to people that go unemployed. So I'll do my best to do the whole presentation in English, but I have completed my studies in French at the University of Montreal. My PhD thesis is in French, but lately I've published articles in English as well. So any one or two French words might come up during my presentation. but I'll do my best to keep it all in English. So restructurings are very complex events, and it's not just one stage. It's not just taking one simple decision to go ahead with restructuring. Mostly restructuring is composed of 4 stages. The first stage is when the employer is considering to go ahead with restructuring. The second stage is when the employer has taken the decision to go ahead with the restructuring, but still there remain some details of its implementation. The third stage is when he has taken the decision to proceed with restructuring and has taken decision how to implement it, but has not executed yet. And the fourth stage is that of implementation. If workers and their representatives want to influence the employer during the restructuring process, they have to act as early as possible in order to bring out the employer's ideas regarding restructuring so that they can formulate proposals and have an impact in the employer's decision either not to go ahead with restructuring or to modify the results of the restructuring. How is the restructuring done in Quebec and Canada, in the North America in general? Let's take the example of Miller Company. Miller closes its Saint Jerome plant without warning. The renewal of the collective agreement had been signed 7 days before the closing. This is very important, that the renewal of the collective agreement was signed 7 days before the closing. So on December 19, 2014, at around 3:30 p.m., Miller Canada announced to its employees the closure of its Saint Jerome plant, leaving 71 employees in shock. Following this, the management of the company asked them to leave the workplace immediately. The previous week, as I said, they had signed the renewal of the collective agreement. So for lawyers that do not deal with labor law, in the collective agreement, we have all employment conditions determined by the union and the employer during the negotiating process. So why it happens so? Why are we so brutal in conducting restructuring in Canada and Quebec? The reason is simple. The legal framework regarding worker participation rights during restructuring in Canada is extremely inadequate and offers insufficient rights to protect employees. Like in our case, in Canada and Quebec, if the collective agreement does not provide for an employee participation right during restructuring, the employer can act legally, unilaterally, and go ahead with restructuring without informing, consulting, or the employees, or taking into consideration the fact that this kind of restructuring can substantially modify the work conditions of the employees. Further, there are no legal consultation procedures for companies where there is no union. So these kind of employees are totally unprotected in case of restructuring. And only 40% of employees are unionized in Quebec and 60% are not. So we can imagine what happens with them. Now, the reason I did the study is not only for the interest of the employees, but it's also for the interest of the employers. Because according to studies, many employers regret going ahead with restructuring because without consulting and informing the employees priorly, because sometimes they have to close themselves after restructuring. Why? Because they let go their best employees, the most competent, or they let go a bigger number of employees that they can afford to let go. So a lot of problems come afterwards for these companies. So in terms of legal terms, what do we have in Canada? We have an act, like in Quebec, we have an act respecting labor standards. What do we have in this act? We have only a notice of collective dismissals, which informs the employees that they have been dismissed at the last moment. We have a reclassification assistance committee, which is not mandatory in Quebec. And this committee is very superficial. It only serves as a placement agency, is not really a committee that will inform and consult employees before restructuring procedure has started. And on the federal level, we have the Canadian Labor Code, which is very similar to the Act Respecting Labor Standards. And it offers similar protections, so nothing at all. It provides for a notice of collective dismissal, the same as the law above, of 16 weeks standard period. So you have to give 16 weeks to the employees to let them know that they are being dismissed. And they have a joint, we have actually a joint planning committee, which is mandatory, but it's the same thing. It's very superficial. It only serves to help maybe 10% of employees find other jobs, but not a committee that would inform and consult employees about the restructuring process. And something extra that is included in the Canadian Labor Code is the duty to inform in the event of technological changes. So at the federal level, if we are going to introduce a new technology in the company, the employer has the duty only to inform the employees that these technological changes are being implemented in the company, but no duty to consult the employees. So because we have almost nothing in Canada and the United States, I had a look at the European Union, which is a good source of legislation in terms of recognizing extended rights to employees to participate in company decision-making during restructuring. And we have 4 directives in the European Union, which gradually have created a binding framework for the employer and the duty for the employer to inform and consult employees at the beginning with the first directive to consult the employees in case of collective redundancies. Later on, they move to inform and consult the employees in case of transfers of companies. Later on, in 1994, we had the first cross-border legislation intended to promote employee participation in the decision-making processes of multinationals linked to transnational restructuring, as well as a set of questions linked to the economic decisions of the company. So multinationals would not go ahead with restructuring anymore for cross-border restructuring without informing and consulting employees, but these are directives. Directives are guidelines. They have to be transposed to member states by legislation. And in 2002, we had a very important council directive, which establishes a permanent procedure of information and consultation of employees, not only in the case of collective dismissals and transfers and transborder restructuring, but also in all questions and matters regarding the life of the company. These directives had to be transposed by member states. Now, the approach in labor law and company law, the approach of legislation varies according to member states. The country that is the more similar with Canada and the United States is UK. The labor relations in the UK are very similar to Canada and the United States. Why? Because UK favors the principle of laissez-faire. This is a French term, but that is used in English as well, which is they favor the collective agreements and negotiation to determine the work conditions. They want the work conditions to be determined by the unions and the employer without interference of the states. And also they privilege the employer's power to act unilaterally in some cases. And this was so, as you know, in 1979, when Thatcher came to power, she considerably weakened the unions in the UK, and also privileged the workers power to act unilaterally in most cases. So because the UK is like us, and because the UK was imposed by the European Union to adopt laws that recognized extended rights of participation to employees in company decision making, UK was a good example to see how these types of legislation worked in the UK in order to find a model to improve the laws in Canada and the United States so that we don't have any more restructuring as brutal as we have right now. And this kind of restructuring, although seems fun for the employer at the beginning, ends up badly for him in a lot of cases. So what happens in British law, first of all, when these directives were adopted, they met a tremendous opposition by the British governments. They were against the adoption of the directives because they found that these directives were incompatible with the principle of laissez-faire, which I explained, and the power of the employer to act unilaterally. But the opposition of the UK only delayed the adoption of the directives, but was never able to stop the adoption of directives. Not only they did not stop the directives, but they also had to implement the directives to the UK. So they implemented these directives by adopting at the beginning EPA, Employment Protection Act, and this law imposed the employer to inform and consult the employees before he proceeded with collective redundancies. But what the UK tried to do at the beginning with these laws, they tried to escape the directives by granting a superficial right to employees and only in cases where there was a union in the company. So the directives could not apply to the companies where there was no union, the way the UK adopted the law. So that law was declared against the directives by the European Court of Justice in many decisions, Commission of the European Community versus United Kingdom of Great Britain. You have the references there, and Commission of the European Community later on as well. So they had to adopt new laws on the subject, and so in the UK today they are out of the European Union, but at the time they were in the European Union, the employees had to be informed and consulted by the employer in cases of collective redundancies in companies where there was a union and in companies where there was no union. So this is something extraordinary happening there, which we don't have here. They also adopted a law to inform employees of multinationals based in Great Britain in cases of transnational restructuring. And the most important law, it's the general legal framework of the right to information consultation employees during restructuring in the UK or Great Britain. It's the same laws in this regard, is ICE, Information Consultation of Employees Regulations. So this law provides that the employees have to be permanently informed in cases of restructuring in the company, informed and consulted by the employers. So they can't go ahead with restructuring in the UK without informing and consulting the employees. Because the UK always tried to escape the directives, they have only adopted laws implementing only the minimal requirements of the directives. Still, although these laws are insufficient, including the directives of recognizing a real right to employees to participate in company decision making in a way to be able to influence the employer's decision, still they are more advanced than the laws that we have in Canada and the United States. Why they are more advanced? For example, participation rights recognized by the directives and the UK laws, as we saw, are much more extended than in Canada, because in Canada right now, if there is no union in the company, the employer can go ahead with restructuring without informing or consulting anybody. Also, the degree of involvement of the European and British employees in company decisions surrounding restructuring is higher than that of Canadian employees. Why? Because while the employers here go ahead brutally with restructuring, they have to inform and consult the employees. Whether they can influence their decisions, we'll see later in the presentation, but at least there is a form of dialogue there. They can't go ahead without informing and consulting the employees. Also, these legal frameworks offer the possibility of being informed and consulted on restructuring, leading to collective redundancies, even when collective agreements do not provide for such a right. We saw at the beginning of my presentation that the main problem here is that if the collective agreement does not provide for a right of employees to participate in a restructuring process, the employer can go ahead with restructuring without informing or consulting the employees. That cannot happen in the UK or the Europe, according to European Union directives, because whether it's provided or not in the collective agreement, the employer has to inform and consult employees by law before going ahead with restructuring. Also, these directives and laws offer the possibility of participation for employees who are not protected by a collective agreement because there is no union in the company. When these laws are implemented in a real way and given a real meaning, they have helped the employees many times, not only to influence the substantial decision of the employer to go ahead with restructuring or not, but they have also modified the results of the restructuring. In 2004, in the UK, 49% of the companies in the respondent sample declared having practices of information consultation mechanisms in their company, compared to 40% in 2003 and 35% in 2002. This increase is due to the prospect of the new ICE legislation following the 2002 directives. Between 2003 and 2006, significant changes took place in the employee consultation mechanisms in 40% of the companies in which ICE is applicable. So, seeing that these directives and these legislations in the UK were also insufficient, I applied the capability approach developed by Amartya Sen, an Indian scientist, in 1992 and 1999, which this is a theoretical framework which measures and evaluates the impact and relevance of legislations that recognize extended rights to employees to participate in economic decisions of the company. And he has many capabilities in the capability approach, but the capability that I chose to do my study was the capability for voice. The capability for voice has 4 conditions, which are prerequisites for moving from the degree of employee involvement in company decisions to a real influence on these decisions. What I presented here tonight and what I'll continue to present, it's only the tip of the iceberg of the study, but I'm just giving a general idea of how things work with these legislation and what should be done for these legislations to be improved and have a real meaning and give a real power to employees to influence the employer decisions. So in these criteria, we have the availability of political resources, cognitive resources, rights and remedies recognized by legislation, willingness of employers and shareholders to listen. So in the availability of political resources, we have to see first what these legislations provide to employees in terms of political resources, in terms of being able to form alliances that are able to act at a strategic moment to influence the employer decisions regarding restructuring. So what do we see? First of all, these laws do not even indicate who are the employee representatives, which means that the employer himself can go ahead and appoint representatives on the matter. The role of trade unions is not is not precise. They don't say who are the if the trade unions have a role in appointing the employee representatives. And in the case of ICE as a legislation does not apply automatically to the company. So 10% or 14% of employees have to ask for ICE to be applied to the company. But if the law does not grant a specific role to the union to act on behalf of the employees, the unions are not interested. So what's happening right now in the UK is only a small number. The employees themselves, they don't even know that ICE exists. So what's happening right now is the employees, only a small number of employees has required the application of ICE to their company. And unions, as they are not interested, sometimes the employer himself is asking the application of ICE to the company. Why? Because he's afraid that the unions and the employees are going to ask ICE to be applied to the company. And if they ask first, then the employer cannot control the process of information consultation of employees during restructuring to the company. So it's good to recognize a role to the unions in order to act either to determine who are going to be the employee representatives for information consultation, or to act on behalf of employees and ask for these legislations to be applied to the company so that they can control together with the employer, not let the employer alone decide again. So they don't recognize also to the employees the possibility to act at the strategic phase of a restructuring decision. And this way, we are coming again to the same problem we had before, because if the employees do not have by law the possibility to act very early at the stage of the restructuring, then the employer informs and consults them at the end of the restructuring decision. So we come again to the same problem we had, where the employees are being dismissed without being informed and consulted at the right time. The 2002 directive states in its preamble that timely information consultation is a prerequisite for the success of the restructuring, but it does not determine when they should be informed and consulted. And when things are left vague like that in the air, the employers are not going to respect and inform and consult employees at the first stage of the restructuring decision. The European Court of Justice as well has tried to address this problem, but always refrains itself from telling the employers to inform and consult the employees really early in the process of the restructuring procedure. So the European Court of Justice is using terms like the I&C procedures should have a useful result, etc., but is refraining itself from doing the right thing. In practice, it seems that too often information consultation come into play only after a new situation has been created by management decisions taken by the employer alone without any consultation. So they also should recognize cognitive resources to the employees, but they don't. These legislations don't. So, for example, the training, if the employees, we are saying that they should be informed and consulted, but first of all, they should be trained how they're going to obtain this information, how they're going to conduct the consultation of the employer, and these legislations do not provide for a training of the employee representatives. The content of the information received is also inadequate because these legislations do not define what information or consultation is, and they do not, or they define it very broadly. The availability of employees to produce their own information is not provided by law. Providing their own information, what does it mean? Means that employees should be given the infrastructure to conduct their own research, to process and understand the information, or to ask for the help of the experts to provide them with their expertise. Let's say we have a big restructuring of a multinational. It involves numbers, it involves knowledge in economics, maybe knowledge in science, etc. We can't expect from the employees to process and to know all that information without the help of the experts. And these legislations don't provide that. And the rights and remedies recognized by legislative measures is only two rights, basically, that they recognize: the right to information, the right to consultation. And consultation is not defined as well. We don't know much what is consultation. And also the compromises reached during the consultations are not binding, as is the case for collective agreements. So what is the purpose of consultation then if the compromises reached are not binding? Sanctions as well. The sanctions are very weak, so employers prefer to go ahead with the restructuring in violation of information consultation procedures because the sanctions are very weak. And has been noticed that in countries where sanctions are stronger, they go ahead and inform and consult employees before going ahead with restructuring. The willingness of employers and shareholders to listen to employees, this is not their desire to listen to employees, but is how they are compelled by law to listen to employees during a restructuring. So negotiation is neither included nor excluded by these legislations, which means that employers go ahead and they don't need to negotiate the restructuring with employees. The quality of consultation and information, these laws and directives leave the quality of consultation information free to the discretion of managers. The prerogatives of employers, these laws leave a lot of room for the prerogatives of management concerning economic decisions related to collective redundancies and to restructuring in general. Employees do not have a real possibility of contesting employer decisions and ensuring that their objections are taken into account during the consultation procedures. Despite the fact that these legislations are inadequate, but still much more advanced than the legislations that we have in Canada and the United States, still, as I explained, they are more advanced, but if they respect, I have humbly made some suggestions in my doctorate thesis how these legislations should be improved in order to adopt a better legal framework on the matter in Canada and in Quebec. It has been noticed that we have success stories. Is the case of active consultants in the UK who have acted in a way that respects the capability for voice, and according to studies, the employees have been able to influence the employer's decisions, not only not to go ahead with restructuring, but also to modify the results of the restructuring. A recent example also showing the importance of respecting the capability for voice criteria is with regard to employee participation in a company restructuring decision is the case of Ryanair during the COVID era, where its pilots accepted a 20% pay cut in order to avoid 260 redundancies in July 2020. So thank you for attending my presentation, and have a good day there and a good night here. Thank you. I don't know if there are any questions.
Yeah, are there any questions? Yes, Barbara. Come on up.
Do you see me, by the way?
Yeah, I can.
Yeah,
We can
let me
you,
see if I
yes.
can make you a little larger here. Okay.
Because I don't see myself. That's why I can't control what you see.
There we go. Of course we can, Doctor. Go ahead. Go ahead.
Again, I have a couple of comments about EU law. So since 2010, the European Court of Justice has been renamed to a Court of Justice of the European Union, and the UK is not a member of the European Union anymore. So I'm just wondering, in that sense, of course, I agree with you that the European Union law has positively impacted the rights of employees. And since the Brexit, let's say, has been there any changes in the UK in that space?
That's why I said the UK is not a member of the EU anymore, and the changes cannot be noticed because it's still too soon for the UK to change legislation that they have adopted. They said they'd leave the European Union a long time ago, but it took them time to really exit the European Union. So they are still in the process of changing their legislation. I'm not aware that they have modified ICE and other legislation yet to minimize the employees' right of participation. I was invited in London 4 years ago, actually, when they decided to quit the European Union. And actually, they invited me as an expert on this matter to get my ideas on the modification of legislation in terms of worker participation. And we gave our ideas, what we had to say. We're about 15 people that have studied the UK law on the matter, and I'm not aware that they have adopted new laws to minimize the worker right of participation and grant more rights to employers to act alone. And I don't think it's a good thing, because if they really see the studies, the employers themselves, they are seeking for help on the matter. They regret letting go their best employees because they didn't inform and consult them timely, and they regret letting go a large number of employees.
Any other questions? Okay, we're behind the time. I do have I'm not sure, I have a question of my own that I was going to ask, and that is that does the fact that there are the potential representatives for the unionized employees and non-unionized employees, does that create a clash over who's controlling what, or does it slow down the process, or has there been any studies as to whether or not that there is a division of authority there that might be challenging for the restructuring court?
Your question is excellent, and I have included, in my study, I have included a good chapter on the matter, but it's in French, and maybe I'll publish it in an article in English. That's the idea of the union. So they even opposed at the beginning. They did not like this idea of information consultation in cases of restructuring. They wanted everything to be included in the collective agreement so they could control the matter. But that didn't happen so, and the unions were against at the beginning. But according to studies, there is no clash, actually. Both work fine. The information consultation channel works as well as the collective agreement channel. But what should be done, as I said during my presentation, a bigger role should be recognized for the unions to really be able to choose the representatives of these I&C forums, and sometimes they should be union members where there is a union in the company, and they should recognize a role for the union to seek the implementation of these legislations to the company, because if the unions are not recognized a specific role in information consultation, they are not interested to act. But these legislations don't really impede the union's role, and they help in companies where there is no union. Because if there is no union and no collective agreements, what's left is the legislation. That should be the one helping. So there is no clash in terms of the union according to studies.
Well, thank you so much. And I don't see any other questions now, and I'm going to accelerate forward only because we're a little bit behind the time. Migen Dibra of her own law office in Montreal, Canada. Thank you so much for that presentation.
Pleasure. Thank you. Thank you to you too. Your presentation, Attorney Nolan's presentation was excellent and taught me a lot about history of trade and all the matter, which I'm not of the field, but I like it. Thank you.
Good.
Thank you.
That's the idea. Thank you so much.
Thank you. Thank you to you too. Thank you.
Okay. Bye-bye.
Bye.